So you wanna go to war with me? You're talking like you think you're royalty. You think that I'm afraid, but I don't break. I heard you question my stability. You think I'll fall just like a guillotine, but I am here to stay. Won't look away. The storm is coming. Yeehaw! No, you can't control it in my bones. I'm coming for the.
Woo! Just got back from watching Sisu, the Finnish gentleman that struck gold and then got pursued by the Nazis. Today was the first day that you could go see that film. I do highly recommend it. It was a very enjoyable film, kind of like a Quentin Tarantino type vibe to it. In this live stream today, I'm going to start off just by going through the stipulation and agreement of settlement and the, what is this other document? The notice of pendency of stockholder class action and proposed settlement. So how they're going to notify you. And it's mostly going to be the second document. I'm going to read through a bunch of stuff. I'm not going to be paying a whole bunch of attention to the comments because I'm probably going to clip this part and then make it a standalone video for whoever doesn't want to watch a 2-hour live stream. And then I'm going to hang out with you guys and we'll have some fun and go through whatever questions you have. I don't care which side of the aisle you come to. For this live stream, this is just me presenting information, reading from the documents for those of you who don't have access to them. And we can get into the more of the opinion stuff, Q&A, speculation, things like that after we go through the document. So I hope that sounds agreeable. While I have everybody here, I wanted to say a few words. Just to clarify, I feel like I say this fairly often, but since we might have some new folks here and there's a lot of people that, I don't know, what's the word? Lie, make up information out there. First of all, I'm not an attorney. Let's get that straight. I'm reading a document to you. I'm not paid by anybody. I volunteer my time to bring you guys information because there is a bunch of financially uneducated folks putting out clickbait and misinformation, and it really irritates me. And I think that at least one person that is covering the stocks that you like ought to have the sanity to provide you real information from company filings, for example, from financial statements. And I have the ability to interpret those and explain them to you in a common sense financial way. And so sometimes my content might be different than what you're used to hearing. This is not all speculation and hopium, unicorns and rainbows, but I am in AMC and APE just like you guys. And I have been for 2 years. And it is really irritating when people say otherwise. So hopefully that is all clear. The other reason that I focus on the fundamentals and the financials, I hear people say all the time, you know, if I can't get my way with a short squeeze, I want the company to go bankrupt. Let them run out of cash. And I feel like I have an obligation to be an advocate for the other people. You know, you're in a minority if you want this company to go bankrupt if you can't get your way. And I have an obligation to be a voice for everybody. I understand your desire for a short squeeze. I understand it and I get it. I'd love one too. But not everybody is willing to see the company go bankrupt if they can't get their way. That's a little bit selfish. And it means that viewpoint is ensuring that all of us lose. And I will continue to be the voice of everybody. So you're welcome here. Whichever side you're on, but just keep it respectful. I don't engage with trolls, but I think it's probably fair to say in most states, stalking, harassment, reputational harm, libel, all of that is illegal. And I have been keeping receipts now for well over a year. And at a time of my choosing, don't be surprised if you get a knock on the door. Let's just try and be good to each other and realize we're all on the same team here, because I don't appreciate people making up shit about me, and don't think that it's not being cataloged. All right, let's go into some documents. The first one that we're going to look at is the stipulation and agreement here. A lot of this is just a recap of everything that we already know, how we got here. So the thing that I really wanted to highlight in this document, and I already have it highlighted, I've read through all of these twice, is some questions that you guys had about how are they going to notify us. This was really the new information in this document. And we'll get into what the settlement is and how to write letters. We'll get into that in the next document. In this particular document, they did propose, and I don't think that the judge has signed off on all these yet. These were just submitted today, so I expect that she will. But there still could be some changes, okay? But this is what we have. AMC shall provide notice by filing an 8K. They shall post a copy of the stipulation notice on AMC's website all the way through the effective date or when the settlement is complete. And they shall transmit the summary notice over PR Newswire and post a notice on AMC's Twitter account. So it looks like the issue that we were wondering about, spending $3 million mailing it, I didn't see that in here. I think that as far as this document, that was the only thing that I highlighted. Everything else it was already talked about in previous live streams. So let's go over this one, which I do have a lot highlighted in. This is goes over a lot more detail about how we got here to the settlement and who is a record holder and who's going to get paid and what are you going to get paid. You are a record holder for this class action if between August 3rd, 2022 and the time of the conversion and the reverse split, you held AMC common stock. So if you're holding on the day, and I expect that right after the settlement is signed off by the judge at the end of June, AMC will probably already have pre-filed the paperwork with Secretary of State of Delaware and NYSE to affect the reverse split and the conversion. So you are a record holder as long as you're holding it the day before that paperwork's filed. You'll get the settlement or the payout. It does not apply to APE. It's for AMC shares only. It says when is the payout going to happen? It just says it should appear promptly thereafter. It doesn't say like a day, 2 days. I don't have that information. They just say promptly. That's the payout is in this settlement 1 share for every 7.5 shares of AMC that you have after the reverse split. If you would like to object, you may write a letter to the lead counsel. So a lot of people were sending letters to the court. We'll go through the instructions in just a minute of how to write a letter or an email. But remember, you're not going to be mailing it to the court. You're going to be mailing it to the plaintiff's attorney. It doesn't say in here in this document the date. We'll probably get an updated one tomorrow once the judge signs off. But I think it was like 15 days before the actual hearing. Don't hold me to that. I'll publish the date when I see an actual date in here, probably around mid-June. You know, if you want to object, you want to write a letter, it'd be best to do it early. That way you don't have to worry about what the date is, what's the due date. The court has not yet decided on whether to approve the settlement. So the settlement decision will be finalized on June 29th or 30th. So this is a proposal. Everybody has time to object or write letters of support. And then all of that information will be compiled, looked at by the judge, and the decision will happen at the end of June. And it even also could be amended by the judge, right? She might say 1 for 7.5 is not good enough. I mean, that's potentially could happen. I mean, just for example, she could say 1 for 5. So this is the proposal. It is not yet decided if it's approved yet. What's happened in the past 2 months? Plaintiffs reviewed 59,000 pages of documents provided by AMC. An additional 3,200 pages of documents provided by third parties, And the plaintiffs responded to 26 document requests from AMC. This paperwork, by the way, the settlement is submitted to the court by Allegheny's attorney. So when it sounds like it's all being written by the plaintiffs, it was written by the plaintiffs. So they're saying what they reviewed and what they provided AMC. AMC gave them almost 60,000 pages of documents. Like I just said, if the settlement is approved, for every 7.5 shares of common stock AMC that you have after the reverse split, you will get 1 share of AMC, and fractional shares will be paid out in cash. I highlighted this because I thought it was interesting. Lead counsel, the plaintiff's counsel, expects that the price of shares of common will trade based on numerous factors, including the anticipated likelihood that AMC will be in a better position to raise capital to finance its business in the future as a result of the conversion, which is something I've been pounding the table on. Someone asked me earlier today, like, well, isn't it good news if the settlement gets delayed? And, everybody has their own version of good news, bad news. There's today's good news, and I like today's good news, watching prices go up. But there's also good news, bad news 3, 4, 5, 6 months from now. If the settlement was delayed or AMC had no ability to raise cash, could be really bad news for the company. Could be. A lot will depend on what we find out May 5th about AMC's cash position and how well Q2 goes, and then what happens in Q3. But if the settlement goes through at the end of June, all of my concerns that I've been talking about regarding cash should be off the table. You won't hear me talk about them anymore. Everybody's like, thank God, we're sick of you talking about that shit. I get it. Settlement class time, as we said earlier, that is, how do you know if you're in the class? If you hold AMC on the business day prior to conversion, you're in the class. Only record holders of the common stock, AMC, are in the class and entitled to a payment. No ape. What are the parties' reasons for settlement? Now, the plaintiffs say they brought their claims in good faith, and I'm sure they thought and continue to think that they had good reason to bring their claims, as they say. They even say that. We continue to believe their claims have merit, but based upon plaintiffs and lead counsel's investigation and considering the risks of continued litigation, like draining AMC's cash, or maybe they have some debt thing coming up, because we keep on hearing about August. I couldn't find anything specific to August on the debt, but there are risks of continued litigation, and of course both parties have costs. In light of that, they have determined that the settlement is fair, reasonable, adequate, and in the best interest of AMC common stockholders. The part that I highlighted down here is the plaintiffs say that even if they could show a likelihood of success on the merits of their claims for injunctive relief and irreparable harm with respect to the filing of the certificate of amendment, that's to do the reverse split and conversion, lead counsel determined that it was unlikely that the court would invalidate APE. And that's something that I've been telling you guys for a couple months. It would be very unlikely that the court's just going to say APE is illegal. And they go on to say more about that and the reasons why they're saying this. And they put it in bold and italics, and in case there's any doubt. In assessing any balancing of the equities, the court would consider the harm to people who bought APE on good faith. So anyone that bought APE, not just the people that were handed it. If you were just not even aware of what's going on and you bought APE and then the court invalidated it, now that person has harm. And so the court has to consider all of that. And the plaintiffs kind of said, yeah, I mean, we get it. It's probably, considering all of that, it's probably not likely that the judge is going to just rule APE illegal. And then they go into the legal argument about it, though, this Section 242B2 of Delaware General Corporate Law. And this was where I was saying in my reading of that, and again, I'm not an attorney, I did not see any illegality on AMC's part. If I did see it, I 100% would tell you I'm not here to lie to people every day. If I see bullshit, I will call out bullshit. But I'm going to highlight what the plaintiff said here. A recent decision from the Delaware court says that Section 242B requires any special rights for a class of stock to be expressly granted in a corporation's certificate of incorporation. And there's a not in here, so I just want to read this twice. AMC's certificate of incorporation did not grant voting rights solely and exclusively to holders of common stock. What that means is you can go read back from 2013, the original articles of incorporation, and I have. The board has the power to grant rights, including voting rights, to any class of share it wants. That's in the original articles of incorporation. And as long as that was in there, they can pretty much do whatever the heck they want. So it was not illegal from that standpoint. Moreover, in green here, AMC's certificate of incorporation expressly grants the board the ability to issue preferred shares with voting rights. Again, stuff we've talked about here many times. And they finish up by saying, in fact, AMC previously had outstanding shares that had far superior rights to the common stock. And that is those Class B shares that Wanda had back in the day, which are all canceled now. Since Wanda sold them, they were all canceled out. So once the once the plaintiff kind of like realized all this, I think they backed away from the argument that they had any standing under Section 242B. Everything that AMC did was within their rights to do with APE, as far as creating it, assigning voting rights, things like that. So then the argument becomes, well, was fiduciary duty breached by selling a bunch to Antara to sway the vote? So that's where the settlement comes in. I'm sure that's what the plaintiffs were saying. Like, okay, even if it was legal, you still harmed common shareholders by creating APE and essentially diluting AMC. So let's keep going. And that's what they say in this next paragraph. Taking into account plaintiffs' belief that the use of APEs in the Antara agreement was inequitable and likely a breach of fiduciary duty, the plaintiffs nevertheless determined that the most beneficial, the most appropriate way to benefit common stockholders was through a settlement. Sorry, it's not going to be as fast because I lost my highlights on the document. Defendants have denied and continue to deny any allegations of wrongdoing, yada, yada, yada. Typical words that you see in these documents. It's going to be 7.5 shares for every one. There's going to be fractional shares will be paid out in cash. Payment will be issued once the settlement is approved by the court. The other thing, a lot of people were wondering, how are the attorneys going to get paid? The plaintiffs, Allegheny's attorneys. The judge has the sole discretion if the attorneys get paid and how much they get paid. That is what 54, 55, and 56 say. So this settlement will go through even if the plaintiff's attorneys in the judge's judgment don't deserve any payment. This settlement's going through. Now, she's not going to not pay them. She's going to agree to pay them something. In the settlement agreement, it says they agree that it will not exceed $20 million. But everything, what they're going to get paid, is totally up to the judge. What's going to happen on June 29th and June 30th? At the settlement hearing, the court is going to determine if the settlement is fair, reasonable, and adequate to the settlement class. They're going to basically lift the status quo order, write a judgment to, determine whether a judgment should be entered dismissing the action with prejudice and lifting the status quo order. I'll just read what it says. It's easier than trying to explain it. And determine if the attorneys on the plaintiff's side get paid. And then many of you are interested in this. On the 29th and 30th of June, they will hear and rule on any objections to the proposed settlement or to the application that the plaintiff's attorneys have made to get paid. You could even object to that if you want. And finally, there's a catch-all here. Consider any other matters that might properly be brought before the court. All right. How to write the court. The date when it is due by is not filled in yet. As soon as I know that, I'll post it and tweet it out. There is an email here, AMC Settlement Objections at blbglaw.com. Again, now, if you're filing an objection to the settlement, you're not mailing it to the court. You're emailing or writing to the plaintiff's attorneys. They will validate it and then provide it to the special master, who then looks over it and ultimately gets it to the judge. There is also a mail address here. I'm not going to read all this out, but I'll leave it on the screen for a second. They say down here a little lower, it is preferable to email any materials that you wish the court to consider. So I guess they would prefer you email. That email again is AMC Settlement Objections at blbglaw.com. Well, there's going to be a lot of people posting this info. All of this info is going to be on AMC's website, Twitter, and an 8K. Don't worry if you don't get it in today's video. Just going over it at a high level. What must be in your objection or statement of support or any filing or any submission? You must state your objection or support is being filed with respect to this particular case number. You must put in there your name, address, phone number, and if you're represented by an attorney, all of their information. You must sign it. You must put in a specific written statement of the objection or your statement of support and the specific reasons for the objection or support, including any filings that you wish for the court to consider. And you must include documentation sufficient to prove whether you object or support that you are a member of the settlement class, i.e., that you owned AMC between August 3rd, 2022 and the date of mailing in your letter or emailing. What is sufficient documentation? It says you have to put in a copy of your original official brokerage account statement or a screenshot or an authorized statement from your broker. And obviously, they want to see your name, the number of shares, when you owned them, when you bought them. And I heard them say on the phone call, just block out your account number except for the last 4 digits. There'll be, I'm sure, more instructions in the official notification that's going to come out. Anonymous letters are not sufficient. You can write in a letter of objection or support. You don't have to show up. It's okay just to send in an email or a letter. You may not, however, speak to the court in person unless you first file and serve a written objection. So don't just show up if you haven't sent something in. Is how I'm reading that. All right, that's basically it. That is the recap of, these 2 documents